Yes, do we have the council? Just a minute, please. Yes, do we have the council? Can you call the case, please?
Fine. Please, have you seen Mr. Williams? I didn't send the response. Can you help tell him that we have to here?
My lord, can I go ahead and call the case?
Yes, please.
Sitting today, Honorable Justice S. Adeniyi, in the matter of KD 61-2017 between Mrs. Olufunke Oweye versus Kaduna Electric Development Company. Yes, my lord.
Yeah, appearances, please. Appearances, can you hear me?
My lord, the council's mic is on mute. My lord, the council is speaking, but his mic is on mute.
Appearances, please. Appearances, please.
Hello, my lord. May it please, my lord, PK somewhere, my lord, for the respondents, my lord.
You change your shoe. This one is not
Over 3x. Hello? Mic is okay. It's okay.
Well, good morning again, gentlemen.
Good morning, my lord.
Yeah, sorry, it's the network issues. We're trying to figure it out. I hope we will be able to sail through without any issues again. Can you call the case, please, again?
As the copy, my lord.
Can you call the case, please? No, I have to pick it up. Mrs. Lawal, can you call the case? Mrs. Umar, are you there to call the case? Well, appearances, please.
May it please, my lord.
Yes, please.
I
Sorry, my lord.
respectfully remain PK somewhere. My
DK
appearance is for
telephone
the respondent, my lord.
for the
Hello, my lord.
respondent, for the defendant, you mean, or the claim?
For the respondent. Yes,
For
my
the
lord.
defendant,
For the defendant, my lord.
yes.
Yes, my lord.
Any appearance for the claimant, please? Appearances for the claimant. Well, I'll record it that the claimant is not represented.
As the court pleases, my lord.
Judgment. The instant suit was initially commenced by the claimant, Mr. Temitope Oweye, now deceased. On the 9th of December 2019, this honorable court granted an order of substitution of the claimant with his wife, Olufunke Oweye. For starters,
As the court pleases.
I should remark that this judgment was initially slated for the 20th of April 2021, but was further adjourned till today due to the industrial strike of the Judiciary Staff Union of Nigeria, the JUSUN, which has prolonged up till now.
As the court pleases.
The claimant's case, in summary, is that he entered into a contract of employment with the defendant for 2 years and resumed duties in Kaduna as the head corporate services. His contention is that the defendant breached the terms of his contract of employment by not affording him with the opportunity to defend the allegations of misconduct leveled against him before his appointment was terminated. His further contention against the defendant is that he was denied his entitlements and benefits as contained in the letter of offer of contracts of employment. Being aggrieved of the actions of the defendant, the claimants instituted the instant action via complaints and statements of facts filed in this court on the 29th of November 2017, whereby he claimed against the defendant's relief set out as follows. 1, a declaration that the defendant breached the terms of offer of contracts of appointment of the claimant dated the 24th of December 2014 by the letter of termination of contract appointment dated the 5th of December 2016. 2, a declaration that the manner and reasons of termination of the claimant's contract appointment by the defendant as contained in the termination letter dated the 5th of December 2016 are false, wrongful, none are void. 3, an order directing the defendants to pay to the claimants the sum of 200 million naira only as general damages for breach of contract of appointment between the claimant and the defendant. 4, an order directing the defendant to pay to the claimant the sum of 27,443,867 naira, being the total amount of the unpaid entitlements and benefits due to the claimant while in the employment of the defendant.
If I need something.
5, an order directing the defendants to pay to the claimants the sum of 500,000 naira only, being the cost of the suit. The defendants disputed the case of the claimants. The gist of the defense advanced by the defendants in the statement of defense filed on the 9th of March 2018 is that the claimant's employment was properly terminated. The defendant stated that the claimant was issued query and that he failed to honor the invitation to appear before the Management Disciplinary Investigation Committee, hereinafter called the committee, to defend allegations leveled against him. The defendant contends that the claimant's cumulative pension entitlements had been remitted to the claimant's pension fund administration, and it's also denied owing the amounts claimed by the claimants as allowances and other entitlements. At the plenary trial, the claimants testified in person by adopting a statement of oath as evidence in chief and tendered 10 sets of documents in evidence as exhibits. He was thereafter cross-examined by the defendant's learned counsel. The defendant in turn fielded 2 witnesses in support of their defense. The DW1 is Bayero Sanusi, an officer attached to the Human Resources Department of the defendant. He adopted a statement on oath in support of the defendant's case. He also tendered 8 sets of documents in evidence to further buttress his testimony. The DW2 is Abbas Ahmed, a legal officer of the defendant. He equally adopted a statement on oath and tendered 2 sets of documents in evidence. The defendant's 2 witnesses were equally cross-examined by the claimant's learned counsel. Upon conclusion of plenary trial, parties filed and exchanged their written final addresses as prescribed by the rules of this court. In the final address filed on behalf of the defendant on the 27th of January 2021, P.K. Tagwai, Esquire, identified a sole issue for determination in the suit, that is, whether the claimant has proved his claim by cogent and credible evidence to warrant the grant of relief sought. In his final address filed on the 20th of November 2020 and deemed properly filed on the 27th of January 2021, learned counsel for the claimant, John Aneto Esquire, distilled 3 issues as having a reason for determination in the suit, namely, 1, whether the defendant breached the original claimant's contract appointment as per Exhibit C1, 2, whether the defendant is justified for not paying the original claimant's entitlement till date, 3, whether the original claimant is entitled to the relief sought in the suit. The defendant did not file a reply on points of law to the claimant's final address. Upon a proper assessment of the state of the pleadings of the parties, the material evidence led at the trial, the final addresses filed by the contending parties, my view is that the focal issues that is a reason for determination in the suit, without prejudice to the issues formulated by the parties in their respective final addresses, could be recaptured as follows. 1, whether, having regards to the conjunction of the circumstances and events in this case, the claimant's contract of employment was breached by the defendant and thereby entitled to general damages. 2, whether the claimant has proved his case to entitle him to his claim for unpaid entitlements and benefits due to him while in the employment of the defendant. In determining those issues, I should also put on record that I had carefully considered and taken due benefits of the totality of the extensive arguments canvassed by learned counsel for the contending parties in their respective written submissions, into which I shall endeavor to make specific reference as I consider needful in the course of this judgment. I shall proceed to take both issues together. From the evidence on record, it is stating the obvious to affirm from the onset that the relationship between the claimant and the defendant is delimited by a contract agreement. This is clearly seen in that the defendant, by paragraph 3 of the statement of defense, positively admitted the availment in paragraph 4 of the claimant's statement of facts. I should also remark that the case put forward by the claimant is substantially documentary evidence. In that circumstance, the focus of the court is directed principally at the documents tendered by the parties as the yardstick to assess the oral evidence adduced by the witnesses on either side of the divide. This course is in consonance with the established legal propositions that documentary evidence, being the best evidence, is the yardstick or anchor by which to assess the veracity or credibility of oral testimony, and that extrinsic evidence cannot be admitted to contradict it, add, or vary the provisions contained in the document. See Section 128 of the Evidence Act 2011 on the above issue. See also the cases of Skybank PLC versus Akinpelu, and the case of Undubisi versus Bauer, citation supplied. Essentially, the case of the claimant to CW1 is that he was offered a contract of employment by the defendant for 2 years, commencing from 5th of January 2015, with an option to renew for further 3 years. The claimant testified that he resumed duties with the defendant in Kaduna as head corporate services, that thereafter he repeatedly applied for his entitlements or benefits for annual family vacation tickets for years 2015 and 2016, as stated in his letter of appointment, but the same was never paid by the defendant. That his statutory pension contributions was never remitted by the defendant, and that his pay as you earn task was deducted from his monthly salary, but was never appropriately remitted by the defendant. The letter of offer of appointment, dated the 24th of December 2014, containing the terms of his employment, was admitted in evidence as Exhibit C1. The claimant further testified that he was transferred to Kafencha office of the defendant for 5 months, and that upon his transfer, he was entitled to daily per diem of 30,000 naira, which was never paid by the defendant in spite of repeated demands. Exhibit C4 and C5 was admitted in evidence as applications made by the claimant for his annual vacation and daily diem upon being transferred to Kafencha. The claimant testified further that on the 28th of November 2016, the defendant made a report against him to the Department of State Security, Kaduna State Command, that he was picked up on that same day, that in the evening of the same day, he received a query containing some allegations from the managing director or chief executive officer, which had totally strange to him. That he replied the query via email dated the 29th of November 2016, and that he received a letter of termination of appointment on the 5th of December 2016. The query dated the 28th of November 2014. The claimant's reply to the query dated the 29th of November 2016, and the letter of termination of appointment were admitted in evidence as Exhibit C2, C7, and C3 respectively. The claimant also testified that while in the employment of the defendant, he was very diligent and contributed to the progress and the finances of the defendant, that he never authored nor sent any email to any of the staff of the defendant, and that he was never involved in any act of misconduct, insubordination, and indiscipline as alleged by the defendant. The claimant contends that the defendant breached the 2 years contract appointment by terminating the contract on the 5th of December 2016, that he was denied fair hearing in the manner his appointment was terminated by the defendant, and that the action of the defendant caused serious injury and damages to his professional career. The works reports, weekly reports of the claimants, and the various email correspondences of the claimants to the defendants, and the claimants' assignments completion reports were admitted in evidence as Exhibit C6, Exhibit C8, Exhibit C9, and Exhibit C10, respectively. While answering questions under cross-examination, the claimants admitted that the defendants inherited the liabilities and assets of the defunct Power Holding Company of Nigeria, PHCN, but that the terms and conditions of his employment was not governed by any other document other than the terms stated in his letter of offer of employment. The claimants admitted that the computation of his claim for his transfer allowance per diem was not stated in his letter of offer of employment, and that the PHCN policy for transfer allowance was not applicable to the defendant. The claimant further admitted that he did not have receipts for hotel accommodation for the refund being claimed. The claimant maintained under cross-examination that he replied the query. At this point, can I ask all the microphones to be muted, please?
Miss Victoria.
Can I ask, please, that all microphones be muted? Thank you. The claimants maintained under cross-examination that he replied the query through email, that he was not aware of the invitation to appear before the disciplinary committee of the defendant, and also denied that he refused or neglected to attend the disciplinary committee set up to investigate the alleged misconduct. The defendant on its part admitted that the claimant was employed as the head corporate services. It further stated that the claimant's contracts of employment was subject to the defendant's condition of service of all staff and the PHCN policy handbook, which was applicable to the claimant as the head of corporate services. The defendant's witnesses testified that the claimant did not report at the Kafencha office when he was transferred, but operated from the Banawa area office, which controls the Kafencha business unit. The defendant's witnesses testified further that the claimant was queried over some allegations, and the query was replied through email, that not being satisfied with the claimant's reply, the defendant activated its disciplinary proceedings to investigate the allegations that the claimant was invited to appear before the disciplinary committee, but that he refused and neglected to appear and defend himself before the committee. The defendant maintained that the claimant is not entitled to his claims for benefits and other entitlements. The following documents were admitted in evidence to further support the defendant's case: letter of invitation to appear before the disciplinary committee, claimant's solicitors' letters to the defendants, replies of the defendant's solicitors, condition of service and book of PHCN, investigation reports on the alleged security breach, correspondence between the claimants and one Umar Yakubu Mohammed, claimant's query and reply of the claimant to the query as exhibits D1, D2, D2A, D2B, D3A, D3B, D4, D5, the 6, D7, D8, respectively. Now, the disputes between the parties in the main is the determination of the terms and conditions applicable to the claimant's contracts of employment, and when determined whether the applicable terms and conditions were breached by the defendants. The testimony of the claimant is that upon being engaged by the defendant as a new startup company, the defendant had no policy handbook that contained the terms and conditions of service. The claimant maintained that the conditions of service governing his appointments was contained only in Exhibit C1, his letter of appointment, and that the PHCN policy handbook was never applied to govern the terms of his contract while in the employment of the defendant. The defendant stands through DW1 and DW2 on the other end, is that the conditions of service handbook in use at all material times for the terms and conditions of the claimant's employment and for its members of staff to date is the PHCN condition of service handbook. The disputes between the parties having been clearly identified in the foregoing, I now turn to determine the terms and conditions applicable to the claimant's contracts of employment. The first port of call is Exhibit C1. The contents thereof revealed the terms of the contract employment. It states in part as follows, I quote, "Following your successful performance at the test and interview held recently at our office, we are pleased to inform you that you have been offered contract appointment as head corporate services with the Kaduna Electricity Distribution PLC with effect from Monday, 5th January 2015. Your appointment will be governed by KAEDCO's condition of service for all staff and regulations that may be enacted by the management of the KAEDCO from time to time." End of quote. The letter of offer went further to state the details of the obligations and expectations from the claimant with respect to his duties and the details of his salary and other benefits. The said benefits are reproduced as follows. I quote, other benefits include 1, annual holiday tickets for self, spouse, and 5 children based on applicable class of grade. 2, incentives tied to the company bottom line. KAEDCO will also provide health insurance cover for you, your spouse, and up to 4 children where applicable. End of quote. On the issue of the applicability of the PHCN handbook, Exhibit D4, to the claimant's employment, the submission of the Learned Claimants Council is that all the pleadings and arguments of the defendant predicated on the PHCN handbook are completely defeated by Exhibit C1 because Exhibit D4 was not in use while the claimant was in the employment of the defendant. The Learned Claimants Council submitted further that Exhibit C1, being documentary evidence, is the yardstick to assess the credibility of oral evidence. In support of its proposition, Learned Claimants Council relied on the cases of Bidlev versus the Dingy, a case of GmbH versus TD Industries Limited, and the case of Okafor versus Okafor, citations all supplied. On its part, Learned Counsel for the defendant argued that the use of the phrase, I quote, other regulations that may be enacted from time to time, end of quote, in Exhibit C1 presupposes that the terms and conditions of service stated in the letter of appointment are not limited to the terms stated therein only. Learned Counsel further argued that by complying with the instruction and or directive to relocate to Kefincha, the claimant by his action confirmed that his employment was not subject to his letter of employment only, but that the conditions of his employment also but that it was subject to the conditions of his employment also, subject to other conditions. The defendant stands through DW1 and DW2 is that the condition of service and book in use at all material times when the claimant was in the employment of the defendant and to date is the PHCN condition of service and book. Now, it is borne on the evidence on record that the claimant testified on their cross-examination that his claim for relocation allowance per diem and the calculation for travel benefits and entitlements are not stated in his letter of offer of employment. It is also borne on the records of the court that the claimant alleged that he was not invited by the defendant to appear before a disciplinary committee and that he was never made to appear before any disciplinary committee and therefore alleged that the defendant did not give him the opportunity to defend the allegations. I should remark that the disciplinary procedure or measure that the claimant sought to be adopted by the defendant was not stated in his letter of offer of contracts of employment. The procedure was stated in the conditions of service of PHCN, that is Exhibit D4. The settled law is that a party cannot approbate and reprobate, that is, it cannot blow hot and cold at the same time. See the cases of Ude versus Nwara, the case of AG Rivers State versus AG Akwa Ibom State, citations supplied. The claimant cannot state, on the one hand, that the conditions of service of PHCN is not applicable to his employment, and yet still come under the cover of the same conditions of service of PHCN to allege violation of the disciplinary procedure. Furthermore, the claimant cannot allege that the conditions of service guiding his employment is as contained in his letter of offer of employment only, and yet resort to the PHCN condition of service and book for his claims for the relocation entitlements. The law does frown seriously at such attitude of parties, approbating and reprobating in the court, thinking perhaps that they might in so doing win some cheap points in issue if the court was so gullible as they thought it to be. In my view, the arguments of the learned claimant's counsel with respect to his interpretation and understanding of Exhibit C1 appears to be a far too narrow and simplistic interpretation of the said exhibit. I have no doubt whatsoever in my mind that on the strength of the evidence on record, as earlier stated above, the appointment of the claimant was governed not only by Exhibit C6, but was equally governed by the PHCN conditions of service, Exhibit D4, and I so hold. Now, as correctly submitted by learned counsel for the defendants, the burden and standard of proof in civil suits lie entirely on a party who asserts the existence of the facts to prove same, or on the party who will fail if no evidence is led to prove the facts asserted. See Section 133 of the Evidence Act. The claimant has alleged that the manner by which his appointment was terminated by the defendant was in breach of his contract of employment. A breach of contract connotes that the party in breach had acted contrary to the terms of the contract, either by non-performance or by performing the contract not in accordance with its terms or by wrongful repudiation of the contract. See the cases of Pambisga Nigeria Limited versus FBN Limited, the case of Best Nigeria Limited versus Blackwood Orge Nigeria Limited, the case of Sokwa Oil Marketing Company versus BON Limited, citation all supplied. It is settled law that in an action for wrongful termination of employment, the onus is always on a claimant to prove the terms of agreements allegedly breached. It is from the terms of the agreement, which is binding on both parties, that a court will determine the terms of contract between the parties and the rights of the parties thereto. Exhibit C1, D4, and C3 is therefore crucial to determination of the terms of contracts of employment agreed by the parties. It is equally right that in a purely master and servant relationship in which the relationship is purely contractual, as in the instant case, once there is a purported termination of employment, the court will rarely make an order that it still subsists. This is on the principle that the court cannot force a servant on an unwilling master. However, a termination of employment by the employer will be wrongful if it is in breach of the terms and conditions of the contract. See Gedem versus NEPA, the case of Texaco versus Texaco Nigeria Limited PLC versus Kende, and the case of Oshisoya versus Afribank Nigeria PLC, citation all supplied. I had earlier reproduced the relevant parts of Exhibit C1, the letter of offer of appointment, which contained the terms and conditions of the contract employment. As earlier held, the conditions of service of PHCN Exhibit D4 also governs the relationship of the parties. I have taken liberty to reproduce the relevant portion of Exhibit D4, the PHCN conditions of service that relates to contract appointments. Section 3.2 thereof states as follows, I quote, hello.
Hello, everybody. It seems my Lord is having issues with our network. Can we just all hold on a bit, please? Thank you. My lord, your microphone is on mute, my lord.
Hello, everybody. Can you hear me?
Yes, my lord.
Okay, I'll continue now. I note that exhibits, okay, let's go on. Let's just move fast. Learned Counsel submission on the issue of breach of contract is that the claimant's appointment as stated in Exhibit C1 was for 2 years at the first instance with effect from 5th of January 2017, and that the defendant breached the terms of contract of appointment by the letter of termination of appointment dated the 5th of December 2016. The defendant did not deny the averment in paragraph 3 of the statement of facts that the duration of the contract's employment was for 2 years. From the surrounding circumstance of the instance case, it is crystal clear that the defendant breached the terms of contract of employment by terminating the claimant's appointment before the expiration of 2 years' term agreed as parties, as so hold. The tried position of the law is further that in an action of this nature, where breach of contract is established, the only remedy available to the claimant is in damages. In other words, where two parties have made a contract, which one of them has broken, the damages which the other party ought to receive in respect of such breach of contract should be such as may fairly and reasonable be considered either as arising naturally, that is, according to the usual course of things, from such breach of contract itself, or such as may be reasonable be supposed to have been in the contemplation of the parties at the time that made the contract as the probable result of the breach of it. In such circumstances, the claimants will be entitled to be restored in so far as monetary compensation can do to the position it would have been had the contract had not been breached as depicted in the maximum restitutio in integrum. See the cases of Okongwu versus NNPC, the case of Oji versus Ayanso, the case of Adekunle versus Rockview Hotel Limited, and the case of Cameroon Airlines versus Otituzu. Citations are supplied. In the present case, the court has found as fact in the foregoing that the defendants breached the contracts of appointment by terminating the claimant's appointment before the end of the duration of the contract as agreed by parties as stated in Exhibit C1. The claimant is therefore entitled to his claim for damages. This is the salary he ought to have been paid if the contract agreement had not been breached by the defendant and are so hold. The claimant also alleged an infraction of his fundamental rights to fair hearing as guaranteed under Section 36(1) of 1999 Constitution as amended on the disciplinary procedure adopted by the defendants resulting to the termination of his appointment. Learned Claimant's counsel submission is that the claimant was not given the opportunity to defend the criminal allegations that were leveled against him as stated in Exhibit C2, the query, and Exhibit C3, the letter of termination of appointment, and thereby violated the claimant's rights to fair hearing. Learned counsel cited the cases of Arije versus Arije, the case of Arobike versus NNELMC, and the case of Federal Polytechnic Mubi versus Yusuf. Citation also applied. The defense put forward by the defendants is that a query was issued to the claimant and that not being satisfied with reply of the claimant. The defendant invited the claimant by Exhibit D1 to appear before its management disciplinary committee set up to investigate the allegation levied against him, but that the claimant refused, neglected, and ignored the said invitation. The defendant further maintained that it adhered to the disciplinary procedures by calling witnesses to testify at the committee, that thereafter a decision was made to terminate the claimant's appointment, and that the committee made its recommendation to the management in its report, that is Exhibit D5. Now, it is settled that before an employer can dispense with the service of an employee under the common law, all it needs to do is to afford the employee an opportunity of being heard before exercising his power of dismissal, even where the allegation for which the employee is being dismissed involves accusation of crime. Say the case of Ransom Kuti versus AG Federation, and the case of Yusuf versus UBN. The established facts through defendant's witnesses is that the claimant was invited to the disciplinary committee. The claimant admitted that he replied the query via an email, that is Exhibit C7. From the contents of Exhibit C7, dated the 30th of November 2016, I am of the view that the claimant had by his conduct resolved not to participate in the investigation of the disciplinary committee set up by the defendant. The relevant portion of the said exhibit states as follows, I quote, "Since you already referred the matter to the DSS, and I did spend the entire day of Monday, 28th of November 2016 at the DSS office, Kaduna, appreciate that we allow the DSS office to complete their investigation on the matter because, I quote, your preliminary findings are not accurate. Please be informed that I handed over the Corolla, laptop, office keys, etc. to your nominees that laid siege on me in the evening of Monday, 28th November 2016. I await DSS investigation reports because my character has been assassinated by the action of Kaduna Electric." End of quote. It is established that the principle of fair hearing is one of substance and not a mere technical rule. Hence, the question is whether a party who is entitled to fair hearing, who is desirous of being heard before his fate is decided, had in fact been given ample and adequate opportunity of being heard as provided under the applicable rules of the court, the applicable law. Beg your pardon. See the cases of Ahmad versus Sahab Enterprises Nigeria Limited and others, the case of Olorunto Bauju versus Attorney General Federation, citations supplied. To put it differently, the important thing required of the defendant by the rules of natural justice and the provisions of Section 36(1) of the Constitution of 1999, as amended, applicable to this case, is that to convey to the claimants that a meeting was set up to investigate the allegations made against him. Aside from the invitation to appear before the committee, the defendant also tendered the report of the committee, that is Exhibit D5, to further strengthen its defense. It is crystal clear from Exhibit C7 and D5 that the claimant was given opportunity to defend himself. The defendant in the instance case afforded the claimant the opportunity of being heard, which he failed to utilize before the defendant exercised its power to terminate his appointment. The claimant's complaint of not being given opportunity to be heard as baseless, lacks merit, I so hold. In proof of his claim for annual family vacation tickets,
and relocation allowance for being transferred to Kafanchan. The claimants testified that the said entitlements were stated in Exhibit C1. The annual family vacation tickets claim are for the years 2015 and 2016 at 2,950,000 naira per year, totaling 5,900,000 naira. The claimant testified that he is entitled to the relocation allowance from Kaduna to Kafanchan at the daily per diem rate of 30,000 for 5 months. Exhibits C4 and C5 were admitted in evidence to prove these claims. Learned counsel for the defendant submitted that the claimant did not prove how he arrived at the calculation for these claims. Learned counsel further submitted that there is nothing to prove on the face of Exhibit C1 that the claimant is entitled to relocation allowance as claimed. As I had earlier held, Exhibit D4 also regulates the contract between the parties. Section 418 thereof states as follows, I quote, termination of appointment means loss of appointment without loss of earned benefits, end of quote. The pertinent question now is that the claimant and the benefits being claimed? The answer to this poser is in the affirmative. However, as correctly submitted by the learned counsel to the defendant, the claimant did not prove how he arrived at the sum claimed. The claimant's claim in Relief 4 is for 27,443,811, being the total amount of unpaid entitlements and benefits due to the claimant while in the employment of the defendant. It is right that claims for allowances and/or benefits are claims for special damages that must be claimed specifically and proved strictly. See the cases of NNPCs versus Clifford, Nigeria Limited, and the case of 7-Up Bottling Company PLC versus Augustus, citation supplied. In the case of Mr. Mohammed Donguz and others versus ENL Consortium Limited, 2015-60 Nigerian Labor Law Report, Part 2, 39, verse that it is the claim, and employee can not only claim if an entitlement, an employee can only claim if an entitlement is shown. An entitlement is shown by reference to the law that gives it the collective agreements from which the entitlement was agreed on between the contracting parties, or the conditions of service governing the relationship of the employer and his employee. Secondly, the employee who claims must show how he came by the quantum of the sums claimed. This court also cautioned that it may be fatal if, in proving an entitlement, and even if the instrument the employee does not indicate the clause, section, article, the entire expects that it is the court that will shop for the claim prayed for. This is the context within which the claimants can succeed in the present case. I totally agree with the learned counsel for the defendant that the claimant did not refer to any law, documents, contracts by which he calculated this amount for his
entitlements. In the circumstance, therefore, the claimant failed to discharge the burden of proof to entitle him to this claim, and I so hold. Birthing, the court's analysis of the totality of the material evidence adduced on record as demonstrated in the foregoing. Therefore, I must resolve the issues set down for determination in the suit, encompassing the issues respectively formulated by learned counsel for the respective parties, partially in favor of the claimants, as seen by the evidence on record. This suit is rooted in the sanctity of contracts freely entered by parties in the suit. In this court, in that regard, has a burden duty to ensure the enforcement of the contract agreement executed between the parties. In the overall analysis, the court judges the claim of the claimant as meritorious in part. For the avoidance of doubts and abundance of clarity, judgment is hereby entered in favor of the claimant in part against the defendant upon the terms set out as follows. 1, it is hereby declared that the defendant breached the term of the contract appointment of the claimant by the letter of termination of appointment dated the 5th December 2016. 2, the defendant is hereby further ordered to pay to the claimant forthwith the sum of 2,333,625 naira only as damages for breach of contract. 3, it is hereby further ordered that the defendant shall pay the sum set out in 3 above within 60 days to the claimant. And 4, cost of the action is hereby assessed in the sum of 100,000 naira only, payable by the defendant to the claimant. You can unmute your microphones now, please. Thank you. That's the judgment of the court.
As the court pleases.
We are very grateful, my Lord, for the well-considered judgment, sir.
Yeah, who am I? Who is talking, please? So he's making a remark.
I am John Ineto for the claimant, sir.
Yeah, you did not announce your appearance earlier, so I will just record it now, sir.
I'm sorry, my Lord, it was network issues. I made attempts, sir. Yes, my Lord. My name is John Ineto.
Okay, I've recorded your appearance, sir. Your appearance has been recorded, sir.
As my Lord, please, my Lord, we are very grateful for the well-considered judgment, and we pray God for more wisdom and strength and long life to my Lord. We are grateful, sir.
Thank you. So the judgments will be posted on the NICM platform immediately. But you might only be able to obtain the copies of the judgment. I'll try and send it over to Kaduna as soon as possible. So until the Jusun strike is over, before you can make any application to have the CTC of the judgments.
We are grateful, my Lord. We are grateful,
yeah, thank you. But it will, like I said, it will be posted on the NICM portal this afternoon, so you can always access it yourself until you can obtain the CTC.
As the court pleases.
Thank you. The court will rise. We can leave the meeting now. Thank you.
Thank you, my Lord.
I wish you a great day. Thank you.
Thank you, my Lord.
Thank you, my Lord. This